Defendant, Osceola Township, appeals by leave granted by the Circuit Court's order overturning the decision of Defendant's Planning Commission. By addressing public convenience and necessity, the Circuit Court therefore ordered Defendant to issue the requested zoning permit. We conclude that there are two plausible ways to make grammatical sense of the ordinance provision, both of which arrive at the same outcome, and neither of which supports plaintiff's interpretation. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So you may have heard of Nestlé, the sort of mega giant corporation that's got its paws in a whole bunch of stuff, one of which many people have heard of is bottled water. And Nestlé has been, it seems like they have special privileges wherever they go to extract water for bottling and then reselling that bottled water back to people who need water to live. Well, Nestlé has been accused of underhanded tactics, or at least aggressive tactics, in protecting their rights to bottle water. Sometimes they get the right to bottle water even in the middle of a drought or even in the middle of other people's needing water. So it seems a little bit off-sided or unfair, maybe. So I thought you might enjoy seeing Nestlé get smacked down by an appeals court panel after they thought they won at the lower level. And it's a really interesting detail that they try to say here, that bottling water is a public service. And we're going to hear whether the State of Michigan Court of Appeals thinks that bottling water is the same thing and deserves the same rights and everything as individuals' access to drinking water. Let's take a look. This is the Nestlé Waters North America Corporation versus the town of Osceola. So defendant, Osceola Township, appeals by leave granted by the Circuit Court's order overturning the decision of Defendant's Planning Commission, denying the request of plaintiff, Nestlé, for a permit to construct a booster pump building on a location zoned for agricultural uses. Now, they said agricultural uses, but I heard it was a park that children played in. I don't know. Maybe there's some like overlap there or some misreporting. Let's keep looking. The Circuit Court ordered defendant to issue plaintiff the zoning permit. We reverse. So we're the appeals panel here. This is a 3-judge Court of Appeals panel, and they say in their background, the Circuit Court's orders summarize the background as follows. Plaintiff currently operates a well house and a water pipeline in Osceola County. This project was constructed in 2008 and transports water pumped from a well at White Pine Springs to a load station located in Evart, Michigan. The pipeline runs in part across real property owned by Spring Hill Camps. Spring Hill Camps has consented to allow plaintiff to build the building in question on their property. This would allow the booster pump to be installed near the midpoint of the pipeline. The property owned by Spring Hill Camps is located in Osceola Township in the A1 Agricultural Zoning District. Okay, so just in case you aren't familiar with zoning, maybe you haven't played SimCity, or what's the latest one? City Skylines.
City Skylines.
Yeah. You have different, this is a real thing. Cities will have different zones so that you don't end up with a waste incineration plant next to a hospital or a school, or, residential housing next to a polluting industrial plant or something. You make a section of your city for industrial, downtown section that's meant for commercial and a little bit of residential, and then sections of residential here and there. And that helps create a plan for the growth of your area. There is such a thing as unzoned, and unzoned cities or unzoned regions end up having a mixture, and things will be right next to one another that you might not think make very much sense to put right next to one another, and you might even end up having some problems. And you can see what happens then when a area grows without zoning and then tries to figure out how to incorporate people and residential sort of city management, modern city management practices and everything. You might get a train that goes straight through the middle of the main street of the city, because people weren't thinking about it when the city cropped up. They thought about it a little bit too late, and the train and everybody was already there and kind of have a historical right of way that's probably not going anywhere without some exercise of eminent domain. And you might need that cargo train to keep the city alive in the first place, so what do? You might not have the money to fix it because you didn't think about it back then. How, are you doing that much better now that you're going to be able to fix it now? Maybe not. Hey, even New York City has the problem with not being able to keep their subways up to date. The rumor is that they're never going to be able to update it unless there's some influx of cash somehow or something. Plaintiff requested zoning approval to build a 12 by 22 building, which would house a booster pump along the existing pipeline. On November 22, 2016, the Planning Commission adopted 2 resolutions finding that the booster pump building complies with all standards applicable to special land uses as stated in the zoning ordinance. However, it denied the zoning request, finding that the request fell under the classification of essential service and therefore applied a public convenience and necessity standard. Neither the meeting minutes nor a resolution of the Planning Commission contain any reason or explanation why this project was classified as an essential service. The Planning Commission found that this public convenience and necessity standard was not met. The Zoning Board of Appeals ended in a 1-to-1 tie vote, and pursuant to a zoning ordinance, a tie vote results in the Planning Commission's decision being upheld. So the Planning Commission seems to have denied the permit to build the pump because it was not an essential service. Plaintiff, Nestlé, pursued the booster pump facility in anticipation of obtaining final approval of its request to substantially increase the amount of water it is permitted to withdraw from its White Pine Springs well. So they're also increasing the amount of water coming from the well, and that needs a whole analysis over whether the wellhead can really support, and then provide, can you really withdraw that much more water from the wellhead and still supply adequate drinking water to other people down the line? Remember, these wellheads are supplying water that might make it back into the water table, that might make it back into the water drinking supply as it flows and such. So you are removing gallons per minute, however it is. I think it's a couple hundred gallons per minute from the drinking water supply if you don't do this right. The well, known as PW101, pumps water from the ground in Osceola Township for plaintiff's commercial production and sale of bottled drinking water. Plaintiff's permit to increase how much water is permitted to pump is the subject of other proceedings and is not before us in this matter. So we're not deciding whether it's allowed to pump more or pump less. This is about whether it can build the building. We have taken judicial notice of some of plaintiff's public submissions in the other matter, though. A circuit court reversed the Zoning Board of Appeals, reasoning that water was an essential service and plaintiff's commercial bottling operation supplies a public demand, so plaintiff's booster pump facility is therefore an essential public service. The circuit court concluded that as a consequence, the Planning Commission and Zoning Board erred by addressing public convenience and necessity. The circuit court therefore ordered defendant to issue the requested zoning permit. They review the appeal de novo. When you're in law school or when you're a lawyer, you have to understand your standards of review and scope of review. The de novo is the standard of review, and the scope of review is probably based on the existing record. So de novo means they can review things brand new. They don't have to defer or assume that some lower court's ruling is good. They can just start from the beginning and figure out whether their analysis of the facts would fall the same way. And if the scope of review is based on the record, then they're going to review everything in the record, but they're not going to review things outside of the record. As an initial matter, the circuit court's conclusion that plaintiff's commercial water bottling operation is an essential public service is clearly erroneous. The Osceola Township zoning ordinance references but does not define essential public services in the catch line of Section 2.8, which provides the erection, construction, alteration, or maintenance of essential services shall be permitted as authorized or regulated by law and other ordinances in any use district, it being the intention hereof to exempt such erection, construction, alteration, and maintenance from the application of the ordinance, except those which may be considered a danger to the community health, safety, and welfare. The ordinance further provides it shall be lawful for essential public services to establish and conduct themselves in any district of the township, and except as herein provided, the erection, construction, alteration, or maintenance of essential services shall be permitted in any district as authorized or regulated by law, it being the intention, etc. The ordinance does not define the words essential or service. The ordinance does state that agricultural production is essential to the public health, safety, and welfare, and that the A1 agricultural district was explicitly to be unimpeded by the establishment of incompatible uses of land, which would hinder agricultural practices and irretrievably deplete essential agricultural lands and productivity. We agree with the trial court's observation that water is essential to human life, as well as to agricultural industry, recreation, science, nature, and essentially everything that humans need. However, the trial court went on to conclude that because selling bottled water at a profit supplies a public demand somewhere, it constitutes a public service. A public service means the business of supplying a commodity such as electricity or gas, or a service such as transportation to any or all members of a community, or a service rendered in the public interest. The first definition would not be unreasonable if the sale of bottled water approximated a public utility subject to regulation by the Public Service Commission or a similar entity. The second definition would not be unreasonable if plaintiff was primarily in the business of supplying bottled water to areas that lacked another source of potable water. Plaintiff's commercial operation satisfies neither understanding of a public service. Furthermore, other than areas with no other source of water, bottled water is not essential. The trial court erred in effectively concluding that because water is essential, the provision of water in any form, manner, or context is necessarily an essential public service. Plaintiff contends that its well constitutes a public water supply pursuant to the law. We will discuss below why we disagree with this contention. However, in addition, the definition given to a word in one statutory scheme does not necessarily apply to the same word left undefined in another statutory scheme, even if plaintiff's well is a public water supply. Under the law, the status would have little bearing on whether it is a public service under the ordinance. We conclude that the trial court erred in concluding that plaintiff's facility can be deemed an essential public service within the meaning of the ordinance. Plaintiff contends that its PW 101 well constitutes a public water supply under the law. We disagree. Importantly, the law provides a number of relevant definitions. In relevant part, it provides as follows. Bottled drinking water means water that is ultimately sold, provided, or offered for human consumption in a closed container. Community supply means a public water supply that provides year-round service to not fewer than 15 living units, or which regularly provides year-round service to not fewer than 25 residents. The law does not define or explain what it means by for drinking or household purposes. However, it is noteworthy that bottled drinking water is defined as being for consumption rather than drinking or household purposes. So I'm thinking that drinking or household purposes means not so drinking sort of and household purposes, like general purpose water supply for your house, like you would take a shower with or flush your toilet with or whatever. And so, yes, I could see filling up the back of my toilet with bottled water and then flushing it. And people had to do that during the fracking crisis from about 5 to 10 years ago. We generally presume that the legislature intends different meanings if it uses different words. We also strive to give harmonious effect to all provisions of a statute. Water supplies appear to contemplate water being conveyed to a site through pipes, whereas bottled water specifically involves a closed container. In other words, although not stated in lay terms, the law unambiguously provides that a water supply is something akin to tap water and bottled water is distinct. Consequently, there is no legal or factual basis for considering plaintiff's commercial water bottling operation to be a public water supply under the law. Plaintiff nevertheless contends that it is, relying on a 2008 permit issued by the Michigan Department of Environmental Quality. and a 2009 source approval letter from same. The 2008 permit does not mention a public water supply specifically, but it does include connecting the well to the city of Everett's water main. The permit, therefore, arguably supports the proposition that the well does at least partly supply drinking or household water, and to that extent may indeed constitute part of a public water supply. The 2009 letter states that the well is classified as a non-transient, non-community water system under the law. Remember, there were some complicated definitions there. Although the interpretation of the law is entitled to respect, the MDEQ's interpretation, we are not bound to accept it, especially where it clearly conflicts with the plain language of the statute. By definition, a public water supply constitutes a public water system, or waterworks system, that may include a well, but does not mean that the well is the public water supply. A public water supply is unambiguously an interconnected system. It is not one specific piece of the system's discrete components. Thus, the well might be part of a public water supply to the extent it supplies tap water to the city. But in itself, the well cannot be the public water supply. Furthermore, it cannot be a public water supply to the extent that it is part of a commercial water bottling operation. So the justices are separating these things out. If it is really pumping water to the city of Everett, okay, yeah, go to court to protect your right to pump water to the city of Everett. You wanted a permit so that you could increase the water consumption by the city of Everett, fine. But that's not what you asked for. You asked for a permit to bottle more water, not to pump more to the city of Everett as part of a public water supply. That's the difference. Furthermore, under the law, the MDEQ has the power and control over public water supplies and suppliers of water, but only subject to limitations contained in this act. We conclude that plaintiff's proposed booster pump facility is not a public water supply under the law, and the law does not constrain the township to grant plaintiff's requested zoning approval. Plaintiff contends that the Zoning Board of Appeals improperly denied its permit on the basis of the last clause of the ordinance. At issue is whether the requirement to find such structure of building necessary for public convenience and necessity applies to all buildings or structures for essential services, or only to buildings or structures that exceed district height and size limitations. Under the so-called last antecedent rule, we generally treat a reference word or clause as modifying or referring to the immediately preceding word or clause, unless it is apparent that the legislative body intended a different construction. Punctuation is also an important factor in determining legislative intent. Generally, a semicolon is considered a major division between clauses, and a comma is considered a minor division between clauses. A semicolon is also used to demark items in a list of elements that contain internal divisions. The ordinance provision above is not a model of clarity. The public convenience and necessity clause is set off by a semicolon. In contrast, the power to permit clause is set off from the greater height or area clause by a comma. The tender plans and specifications clause is further set off by a semicolon and a furthermore. We conclude that there are two plausible ways to make grammatical sense of the ordinance provision, both of which arrive at the same outcome, and neither of which supports plaintiff's interpretation. The first possibility is that the final sentence is a list of items, one of which contains an internal comma. If so, the entire final sentence is the modifying clause, and each of those items independently modifies the first sentence. In other words, the final sentence imposes three independent preconditions for the approval of the Planning Commission specified in the first sentence. 1. Plans for the building or structure must be given to the Planning Commission and Zoning Administrator. 2. The Planning Commission has authority to allow the construction of buildings exceeding the usual dimensional requirements for any district. And 3. The Commission must first find that any structure is necessary for the public convenience and necessity before approving its construction. Because the three preconditions are separated by semicolons, they operate independently. Because the public convenience and necessity requirement stands alone, it was error to conclude that plaintiff did not need to establish public convenience and necessity. Did you follow all that? I don't know if I did. Under the second possibility, the semicolon combined with furthermore could constitute an even stronger demarcation than a semicolon standing alone. If so, the public convenience and necessity clause would modify only the immediately preceding clause. The immediately preceding clause would be The Planning Commission shall have the power to permit any essential public service to erect and use an essential service building or structure in any permitted district to a greater height or of a greater area than the district requirements established. And that's it in its entirety. The comma establishes that the above clause is a list containing 2 items or it contains 2 subclauses. Clauses. In either event, the public convenience and necessity clause necessarily modifies each of those items. Thus, the power to permit buildings or structures in any district is subject to a finding of public convenience and necessity, and the discretion to allow a height or area departure is also subject to a finding of public convenience and necessity. This construction would again require plaintiff to establish public convenience and necessity before the Planning Commission could exercise its power to permit construction of a building or a structure. So that was super complicated way of saying that if they want to put such a structure in such a zone, they have to get special approval. And part of the evaluation of that special approval is whether it's a public convenience and necessity. And no, it's not. Finally, plaintiff notes that it faced considerable local opposition to its water bottling operation, which plaintiff contends improperly influenced members of the Zoning Board of Appeals or Planning Commission. We agree in part, to the extent that localities may not violate the law simply because popular opinion favors doing so. Nevertheless, Michigan has always regarded the right of the people to locally elect their local government officials as important to the rights of all. It is a necessary inference that local officials should be sensitive to local concerns. Zoning boards of appeals are vested with some degree of discretion. To the extent a commission or board does not exceed the constraints imposed on them by law, which we conclude did not occur in this matter, it would be improper for them to fail to take popular opinion into account. In other words, they're allowed to take popular opinion into account. For any and all of the above reasons, we conclude that the trial court erred in reversing the decision of the Zoning Board of Appeals to refuse plaintiff's permit, and we conclude that the Zoning Board of Appeals properly denied the request. The circuit court is therefore reversed. We direct that the parties shall bear their own costs. On appeal, an important question of public interest is now being resolved. So what did you think of that? It was more or less a technicality that they got shut down on, but the Michigan Court of Appeals does not think that Nestlé's bottled water operation is an essential public service or that they're providing a water system or public water source to a town or something like that. And so in case you hadn't figured it out yet or we're still cloudy on it, that public water system would be more like piping water to an entire town as opposed to bottling water and selling it wherever they feel like it. It's more like if the town didn't have a public water system, Nestlé could provide bottled water as part of a public water system, sure. But the bottled water that they sell on the store shelves is not a public water system or a necessary and convenient public service or something like that. No, Nestlé, you don't have the same rights as individuals have to people, to the water that's in the ground, basically. So I'm glad that they got smacked down there. Let us know what you think in the comments below. Tell me what your experience with Nestlé is. I know a lot of people boycott Nestlé, try to search for all the product. Nestlé owns a large number of companies and products, so trying to boycott them is a difficult thing. So it's admirable when you try to make a difference like that. I don't know that any one voice is going to change Nestlé's mind, but collectively we can all decide not to participate in misbehavior like that. I disagree with Nestlé going after commercial water bottling operations as if they were public services. It's one thing to advocate for your copyrights or defend yourself in court or something. It's another thing to try and pretend that you're something that you're not and get it by the judges. That's just underhanded, and I don't like that. So we call it out. Let us know what you think. And that is our show. Thank you for watching. I am Leonard French, your favorite copyright attorney, and this is your favorite legal news and education channel, Lawful Masses, for you, our lawful masses. Thank you to those of you who support us financially, making this entire show /project/future future legal services benefit corporation, maybe. We're working on it. For making that possible. At the $50 level, our patreon.com/LJFrench supporters and our sponsors.com/law supporters are Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, Joe Tyson, Benjamin Hitov, Steven, and I'd like to welcome two special $50 plus supporters, Rumble in the Bunghole and Cute Grills in your area. I'm sure we have no idea who those two people are. And thank you to the $5 plus supporters who are scrolling on the LED panel this time. I did not screw it up this time, I promise. And will be in the description of the videos that drop. I will put some dog video here where possible, and where not, we'll figure something else out. I love you all. I am Leonard French, your favorite copyright attorney. I will see you on Sunday at 10 a.m. on twitch.tv/lawfulmasses for the live Sunday show. Have a good one. Bye.